stood at the front lines of law, leadership, and public service. Attorney Karen Jimeno, sharp, steady, a lawyer, an educator, turns complex issues into clear insight. Attorney Mike Toledo, seasoned, fearless, a strategist and communicator whose voice has shaped public understanding of law and governance. Together, they make the law accessible, connecting principles with real-life questions, confronting the issues that define our nation. This is Abogado.
Good evening and welcome to Abogado, where we examine how the law shapes real lives and how real lives force the law to evolve. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight, we begin with a situation familiar to many Filipinos. Many couples build a home together, even without marriage. And the belief is simple. If we build it together, we should share it. But in law, ownership can depend on proof and paperwork. So tonight, here is the question we put on the table.
In the Philippines, many live-in couples build a home together but place the title in only one name. In Joseph versus Ursua, the Supreme Court ruled against Ursua despite the title being in her name. The court gave weight to a notarized acknowledgement of the petitioner's contribution, rejected Ursua's denial, and ruled that ambiguity must be interpreted against the party who caused it. The ruling affirmed petitioner's share and right to petition, but most couples have no documents, no receipts, no proof. So tonight, we ask, should co-ownership now be automatically presumed in all live-in relationships?
Joining us tonight is Attorney Mark Kristopher Tolentino, the founding partner of MKT Law Office. He is widely known to the public as Kuya Mark, explaining Philippine law in plain language through broadcasts and online platforms. And he has handled a wide range of family, property, and civil disputes involving couples and domestic relationships.
Also with us is Abogado ng Bayan, Attorney Hazel Yates Mecking, Managing and Senior Partner of MKT Law Firm. She is a private practitioner known for handling complex cases involving criminal, family, and civil disputes. And she is also recognized for constitutional advocacy involving policies that affect access to justice. Attorneys, welcome to Abogado and a pleasant good evening to both of you.
Good evening. Good evening.
Good evening, Attorney Mark and Attorney Karen.
Yes. I'm anticipating magaling magpaliwanag silang dalawa kasi parehong sanay sa vlogging, also sa program.
Correct.
So before we begin, here is how this discussion will proceed.
Statements. Each guest delivers a focused 2-minute statement, laying out their perspective on the proposition. The conversation then unfolds through 2 key subtopics. For each subtopic, the guests take turns presenting their insights in 2-minute segments. Even if they share the same stand, they are encouraged to highlight different angles, supporting arguments, or real-world applications. After both have spoken, we move into the open exchange, a 6-minute free-flowing discussion where the guests engage each other directly, ask questions, and expand on their points. Once both subtopics have been explored, we proceed to closing reflections, where each guest is given 2 minutes to summarize their key messages. Finally, the hosts step in with their own questions. In this 6-minute segment, the guests respond, clarify, and deepen the discussion, ensuring critical issues are surfaced, even if the guests are aligned in position.
And now we begin with opening perspectives. In a very recent Supreme Court case, Joseph versus Ursua, the court recognized co-ownership between live-in partners, even if the property was titled in only one name. The case involved a same-sex couple, and the court applied Article 148 of the Family Code, where property rights depend on proof of contribution. But the bigger question now is, should the law still be proof-heavy? Or should co-ownership be presumed automatically once people live together as partners? Now, Attorney Mike, or rather Attorney Mark, Kuya Mark, you have 2 minutes.
So in this case, may batas kasi tayo, yung tinatawag na 147 and 148 of the Family Code. May tinatawag dyan na property regimes of union without the benefit of marriage. So ang tawag dyan, may tinatawag ba na co-ownership presumed. Pag dalawang klaseng relationship, may tinatawag na marriage or relationship without legal impediments and with legal impediments. When we say without legal impediments, they have the capacity to marry but ayaw nilang magpakasal. So in that case, yun ang batas na mag-govern is co-ownership. There's presumption of co-ownership. Unlike yung may impediment, like for example, same-sex marriage, kailangan same-sex relationship or same-sex union, kailangan talaga ang actual contribution of money, property, or industry. So mag-base yung kanilang ownership is based on actual contribution, not the mere fact that they have relationship. Kailangan may contribution talaga sila. So, kailangan proof of contribution. Yan.
Okay. Thank you, Attorney Mark. At meron ka pang extra 1 minute na spinner. So, I'm interested to hear right now from Attorney Hazel. Should co-ownership now be presumed when partners build a life together to reflect modern realities, including same-sex couples? You have 2 minutes.
Yeah, para sa ating mga nanonood, no, since abogado ng bayan ako, so itatagalog ko na lang, though I understand this is an English show. But ganito kasi yan, kapag automatically ang mga parties, wala talaga silang legal impediment to marry, ibig sabihin, hindi kasal sa iba, ibig sabihin, ang properties na yon na naipon nila habang sila'y nagsama, automatically presumed na sa kanilang dalawa. Pero kung sasabihin ng isa na, hindi naman talaga, ako lang yon. So that is already debatable in court. So nasa kanila na yon mag-prove na akin lang yan. So, ibig sabihin sa 147, dahil hindi ka kasal sa iba, free to marry ka, that means yung property na yon ay presumed na sa kanilang dalawa. Co-ownership governs. Unlike sa 148, ang sinasabi doon, pwedeng kasal ang isa sa iba, pwedeng nagpakasal ng pangalawa, so may legal impediment na. Dito na ngayon maglalabas na kayo ng pruweba kung sa inyo nga ba talagang dalawa ang binuo ninyong property. Kasi kung hindi, then that means para lang yun sa isa. So dito lalabas ang mga resibo, mga kapapilan, dokumento. This is Article 148 of the Civil Code of the Philippines. At dito pumasok ang kaso ni Ursua. Ang kaso ni Ursua is only a modification of Article 148. Bakit? Kasi nga may legal impediment ang same sex. Bakit? Kasi sa Pilipinas, ang pwede lang magpakasal, babae at lalaki. Sa same sex, hindi sila ganun parehas sila ng sex. So definitely, sila ay may legal impediment. Kaya pasok siya sa 148.
Very good discussion so far, no, partner?
Saka talagang makikita mo na habang tumatagal itong diskusyon natin. Importante, taguin yun, itago nyo yung mga resibo. hindi para sa BIR, pero in case. Di ba?
But to add, partner, para sa mga nakikinig, kaya talagang ine-emphasize ni Attorney Mark at Attorney Hazel yung same-sex marriage at pagkakaiba nitong Article 148. It's because pag sinabi nila may impediment, it's because it's not their judgment, diba? They're not making a judgment call. It's more of, yung batas kasi natin does not recognize yung mga same-sex couples.
But in Ursua case, ni-recognize nila yung property regimes ng same-sex union. So yun ang pagkakaiba. Kasi if you read 148, ang sinasabi doon yung mga legal impediment lang na relationship. For example, bigamous marriage, nagpakasal ka na against public policy, first cousin mo, kapatid mo, pinakasalan mo, hindi nilagay doon ang same-sex relationship. But under Ursua case, recognize na yung tinatawag na same-sex relationship.
So meron talagang dahilan kung bakit ang LGBTQ community celebrated this as a landmark decision.
Ibig sabihin dito, yung batas, if you read yung mga opinions ng mga justices, kailangan ang batas hindi bulag. Kailangan open sila sa relationship na hindi lang yung babae at lalaki kailangan alam ng batas na may mga same-sex relationship, may mga same-sex union na nagsasama na, nagli-live-in na, babae-babae, lalaki-lalaki, and there's a possibility na may mga ma-acquire sila ng mga properties.
Okay.
Yun yan.
Thank you, Kuya Mark. When we return, we begin with our first subtopic, proof and documentation, and whether co-ownership should still depend on written acknowledgement, even when it is clear that two people built the life behind the property. This is Abogado. Welcome back to Abogado. Tonight we ask, should co-ownership now be automatically presumed in all live-in relationships? With us are Attorney Mark Tolentino and Attorney Hazel Mecking.
Now, let's begin with the first subtopic, and that is proof and documentation. In the case of Joseph versus Ursua, the Supreme Court relied heavily on a notarized acknowledgement of third-party interest in real property, where the titled partner recognized that the other partner financed about or around 50% of the property and the renovation cost.
Attorney Mark, many couples don't keep records. No receipts, no written agreements, no acknowledgements while they're happy together. If courts require strict proof before recognizing co-ownership, does the law still protect the reality of live-in relationships?
It depends to what kind of relationship. Is it a relationship na may legal impediment or wala? Kasi if there's no legal impediment, co-ownership is presumed. Hindi na kailangan na may mga dokumento, may mga resibo, may mga contracts, mga ganon. But if it is a relationship wherein there is a legal impediment like same-sex relationship, bigamous marriage, kailangan talaga na may proof because the property regime is based on actual contribution of money, property, or industry. So kung walang proof of actual contribution, ibig sabihin, yung babae or yung lalaki, hindi siya kasama sa property relationship or yung tinatawag na ownership of the property. But for example, wala namang legal impediment, nagsasama sila, babae at lalaki, wala namang single si babae, single si lalaki. So ibig sabihin, any properties acquired by them through their joint effort industry presumed co-owned property. Yan.
So ayan, to your point, partner, hindi mo kailangan mag-ipon ng mga resibo kung, di ba?
Kung walang legal impediment.
Kung Article 147 ng Family Code, walang legal impediment, presume co-ownership. So, hindi kailangan na resibo.
Yes, tama.
Yung sa 148, kailangan. Pero partner, sa totoo lang, ma-47, ma-48 pa yan. Itago nyo ang resibo. Manigurado, be sigurista. Believe you me. That's free legal advice, by the way.
Sometimes kasi, pag relationship, if you're okay pa, bulag ang pag-ibig. But pag nag-away-away na kayo, doon mag-start, o saan yung mga resibo? Doon pa lang hanapin.
Which is, I think, what happened here, no? In Joseph versus Ursua. Thank you, Attorney Mark. Attorney Hazel, how much weight should courts give to a notarized acknowledgement of ownership? And in the more common situation where nothing is written, what should courts treat as proof?
Well, it has already been decided, so we cannot argue with that, no? So the court had given weight doon sa written acknowledgement na proof and evidence na siya ay co-owner doon sa property. But you know, Attorney Karen, I had a lot of clients, no? In our law firm kasi, may mga clients na, mga retirees na from different countries and then they want to settle in the Philippines and then they want to have same-sex relationship. They are matalino na eh. Ginagawa nila, ano bang gagawin namin? Para pag namatay yung isa, hati talaga kami. So, as lawyers, ina-advise namin, gagawa natin ng dokumento. Kailangan may mga pruweba kayo. Ito yung binigay mo, 50% of the property. Example, tigpa 5 million kayo and you bought the property for 10 million. So, sure na may mga dokumento kayo. So, ibig sabihin, matatalino na rin ang mga LGBTQ community. And aside from that, the Ursua case is really an evolution, no? We cannot stop it. We are just here as audience na nag-evolve na talaga ang ating komunidad. May mga same-sex na relationships na talaga, pero hindi pa nag-evolve ang batas natin. We're still referring to man and woman union, no, for marriages. Pero wala pa tayo doon sa mga same-sex marriages and then property. So this is very this is a landmark decision by, I think, Justice Leonen.
I believe so. I
Yeah,
think
okay.
it's just a good one,
So,
Who was 2 years below me in the College of Law.
oh, wow.
And he was my professor. He was my professor.
again.
And then when I started teaching in law school,
Yeah, I
naging
salute
dean ko
Justice
siya.
Leonen. Very, very good social
Yeah.
worker and humanistic talaga siya sa lahat ng bagay. Anyway,
Well, it
so,
reflects social reality.
oh yeah. So it was really very good no na nagkaroon ng ganitong desisyon. So sana ma-adopt din to in the future na mayroon pang maidagdag as we evolve with the community of same-sex na or LGBTQ in that matter.
Well, since we already started with the discussion,
Yes.
now officially, let's open the floor for an exchange for about 6 minutes about the topics that we've
For
talked
example,
about.
yung mga contracts kasi, it is not a proof na totoo ang contract. A proof yung laman ng contract. The notarization, it will only make the private document into a public document. So it means there's a presumption of its authenticity and due execution. So yung mga dokumento na yan is only a proof. So it's up to you paano mo i-prove yan sa court. So hindi ibig sabihin may dokumento ka na ganyan, yun na ang totoo.
So, rebuttable presumption.
Rebuttable presumption yan. Kasi sabi ko nga, the document, kahit na notarize yan, hindi ibig sabihin na conclusive na totoo yung nakalagay doon. There's only a presumption of its authenticity and due execution, making it a public document, not a private document.
And
Ganun
that's
yan.
why people usually ask me, partner, na kung pagka-document, they ask me, kailangan ba i-notarize? And I know sa batas natin, merong mga talagang required na i-notarize in order to
Correct.
be enforceable. Pero hindi naman lahat, di ba?
Hindi lahat.
But to your point, Attorney Mark, yung pag-notarize siya, mas madali siyang patunayan sa korte, di ba? Yung due execution.
The only
Na,
notarization is only a proof of its due execution and its authenticity. Hindi
Yeah.
ibig sabihin totoo ang
Yung
nakalagay
mga
doon.
nakasulat, yes.
And by the way, yung Ursua case is not written by Justice Leonen. Nag-concur lang siya. It's Justice
Okay.
Lopez.
So I
yes.
stand corrected. I stand corrected.
Oo, pero totoo yung mga puri natin kay
Of
Justice
course,
Leonen.
yes. Hindi ko yan binabawi. So, ang kagandahan lang nito, no, nung Article 147 and 148, parehas naman tong presumption, rebuttable presumption, kasi kahit naman wala kang legal impediment to marry doon sa 147, kasi single ka talaga at nagsama kayong dalawa, sabi ng batas, presumptively, parehas kayo-kayo'y co-owner. Pero then again, pwede pa rin, pag nag-away silang dalawa, naghiwalay, pwede pa rin sabihin ng isa, hindi, ako lang talaga. Pwede niyang i-rebut. Same with 148. Ang sabi ng 148, kung sino yung magbigay ng mga dokumento, siya lang din ang owner. Now, ang question natin, what about the notarized document? Well, that's good than nothing, right?
Yes, tama.
So if we're going to weigh evidence now, we're talking about this evidentiary documents. We have object evidence, whatever would that be, but you have evidence rather than no documents at all. So still, it will stand. It has more weight than no evidence at all. Kasi we are talking as to how much the court give weight to that document. So bibigyan pa rin niya ng weight. Rather than wala talaga. Kaya, Attorney Mike, mag-keep ka na rin ng resibo.
Pareho na kayo.
Dapat may resibo.
Dapat may resibo.
Kaya nga sinasabi ko at the very beginning, talaga importante na itago mo na yung resibo. Kasi maski 147, Article 147 pa yan,
Or
148.
Or even marriage, kahit couple.
And yeah,
Kahit
a couple,
mag-asawa kayo.
yeah. At the end of the day, di ba, sabi mo nga, love is blind. Pero pag nagkaroon ka ng problema at nagkukwentahan na kayo, at least if you are ready with the documentation to prove that what you have actually contributed to the acquisition of certain property, pagbibili ng mga property, lupa, personal properties. Pero ang importante din dito, na I think that has been one of the reasons why the court has evolved. No? They also considered yung tinatawag nilang industry. Yung ibig sabihin, in some cases kasi, ang babae ay nagiging housewife.
Yeah.
Pero yung trabaho ng housewife is kasing importante din ang trabaho ng husband na pumupunta sa opisina o nagta-travel abroad. Siya ang ng bahay, alaga ng mga bata. So, paano mo linalagyan ng value yan? Ang court ay nagsabi, may value yan.
Yes,
di ba? May value yan. At yan, sa
That's
aking pananaw,
highlighted in Article 147, Attorney
correct,
Mark. Yes.
correct. Which in my view is a very good development. It actually guarantees social justice. It actually guarantees that everyone's equal. And it recognizes the contribution of the weaker. When I say weaker, it doesn't necessarily mean it's the woman. When I say weaker in the sense na hindi siya siguro yung pupunta lumalabas na naghahanap ng trabaho. At siya ay in charge ng bahay.
Kasi under
Hindi yung breadwinner in the traditional sense.
Kasi under Article 147 of the Family Code, kahit na ang trabaho mo is sa bahay, nagmanage ng bahay, nag-alaga ng anak, presume you are part of the contribution.
Correct.
So, but that is only a presumption.
But
Yes.
for 148, just to be clear, kung same-sex marriage, parehong babae, parehong lalaki, would that presumption also apply or that type of treatment na yung industry, yung mas nag-aalaga sa bahay o walang ganon?
Walang ganon sa 148.
So, kailangan mo talagang pwedeng malugi yung isa, yung the person who
Yes, tama.
has not given money.
Yes, kasi Attorney Karen, actual joint contribution. Yun talaga ang ginamit ng batas eh. And then there is no other interpretation to that except you have to give proof. Diba? Actual joint contribution of money, property, or industry. So all these are covered, even savings and earnings, no? So lahat ito covered. So sinong makapagbigay ngayon ng pruweba? Sa kanya to. So wala tayong sinasabi doon na presumption. Kasi kailangan lang talaga kung sinong may ebidensya.
And yung evidence, kailangan i-prove sa court.
Kaya nga to 148, it reflects two things, no? Kasi kailangan, wala kang presumption, di ba? You have to prove. Kasi yung 148, actually, sa aking pananaw, this is a reflection of the constitutional guarantee that marriage is not a mere contract but an inviolable social institution.
Yes, tama.
They want to make a differentiation between 147 and 148 kasi ang pananaw ng iba, pag hindi mo dinistinguish ang 147 yung tinatawag na walang impediment, and then yung pangalawa na may impediment at same ang magiging regime, property regime.
Hindi na sila papakasal.
Parang unang-una hindi na sila papakasal. Pangalawa, parang paano na yung mandato nga ng state, no? Na nasa family code, nasa constitution, that the family is the basic unit of society. Nandun lumalabas yung conservatism. Kaya nga nagkaroon ng ganong distinction. Tama ba ako doon?
Tama.
So to that question, I know we're out of time, is it fair to ask na dapat ba talaga nag-celebrate ang LGBTQ community with this
That's a good
decision?
point.
It sounds like parang, what is the other word for it? Ano lang sila? Second-class citizen pa rin when it comes to property.
No, hindi. Kasi ito, yung batas, yung application ng batas, nag-expand. Kasi dati, yung mga marriages lang or relationship against public policy, yung mga bigamous marriages, yung incestuous marriages, kapatid, pinakasalan mo, first cousin, pinakasalan mo, wala nakalagay doon na same-sex relationship. But because of this jurisprudence, yung Ursua case, nasama na yung same-sex relationship. So, ibig sabihin, they should celebrate. Ibig sabihin, yung ating jurisprudence, they acknowledge yung relationship ng LGBT.
Pero Attorney Karen, pwede rin kasi nating sabihin na kahit hindi sila same-sex, partners lang. Partnership, that could also govern between two people eh. For example, tayo, Attorney Mike, mag-partner tayo sa business. Diba? So, parang ganun na rin yung sa same-sex eh. Kahit hindi naman wala tayong relationship, we're just strangers and we agree to make a business, same lang din doon sa same-sex. Nilagyan lang to ng kulay because, you know, there are many LGBTQ communities right now. Kaya parang natuwa sila na, ganun na pala, meron na palang kung sinong makapagbigay ng resibo. Pero ganun din naman, if we are partners, you can give receipt na ikaw talaga yung mas malaking contribution, then the bigger part will go to you. Diba?
So in short, Attorney Hazel, para sa'yo,
para
hindi
sa akin,
siya
parehas lang. Where you're living together or your business partners, it's just the same because you are proving it in court na sino bang may resibo, sino
so
bang may
parang
ebidensya.
hindi siya,
For me, it's not
so much something to celebrate
Yes,
about.
not
Kulang
so
pa tayo
much.
sa batas
Yes.
din for the same-sex
Yes,
couple,
yes.
same-sex marriage.
For me, same lang siya sa ordinary partnership.
Thank you so much.
Tama yung epekto, but yung jurisprudence, nag-recognize doon, parang kinikilala nila ang same-sex relationship. Yun lang, na-enjoy ang mga LGBTQ, not because of the effect na kailangan may actual na resibo, but yung pag-recognize na, in-acknowledge ng jurisprudence, yung relationship ng same-sex.
Maybe because it was mentioned, same-sex,
yun
but
lang.
not really exactly recognizing it because it's not yet recognized in the Philippines,
Yes, tama.
right?
At maigi to na naiintindihan ng mga tao para they know what to advocate for. At least
Yeah.
for those pushing for same-sex marriage, alam nila, hindi pa rin pala kami pantay
Correct.
sa heterosexual couples.
Yes.
Sa kahit nung topic na to, partner, talagang very relevant. Kasi marami talaga sa ating mga kababayan, lalo na doon po na sa urban areas, no? Marami talaga ay live-in couples. No? For one reason or the other, ayaw nilang magpakasal. And then, of course, meron na rin
Magpasakal,
same-sex.
Attorney
No?
Mike.
Or
Magpasakal.
mukhang may hugot yun. But, di ba? May ganun eh. May ganun. For whatever reason there is, they decided that, in some cases nga, sabi ng iba, actually, that's just a piece of paper. And sometimes now, the piece of paper will just destroy the relationship.
Correct.
May kanya-kanyang views.
Yeah.
No? Pero yun, ang importante, dito sa programa natin ngayon, ay we are actually informing, educating, and giving advice to our listeners kasi marami po sila dyan na actually kung ano man yung relationship nyo, kung hindi kayo married, pero hindi naman po, wala naman pong impediment, may karapatan kayo. Hindi kayo married, living in together, pero may impediment, may karapatan pa rin kayo. Ang diferensya lang, doon sa pangalawa, yung may impediment, kailangan ng pruweba. Kaya yung resibo, ulitin ko ulit, itago nyo lahat yun.
Kailangan makwenta ka.
Kasi walang forever.
Pero kailangan
minsan, love kayo ngayon, happy kayo ngayon, but maybe 2 years from now, 3 years from now, nagkaaway kayo.
Pero kailangan nun, Attorney Mike, i-photocopy ang resibo kasi sa ilang taon na yun, na-erase ang
Nag-figure
resibo.
iba eh.
Digital.
Oo, tama kayo.
May database. Hindi, may database.
Sa cloud.
Ang dami talaga advice dito kasi marami abogado. Thank you, attorneys. Up next, we move to interpretation and presumptions. How courts treat ambiguity and whether equal sharing should be presumed once contribution is shown. You're watching Abogado.
Welcome back. You're still watching Abogado. We now move to our second subtopic, interpretation and presumptions.
In Josef versus Ursua, the Supreme Court applied contra preferentum, construing ambiguity against the party who caused it. Should this doctrine apply automatically in live-in property disputes? Or should courts consider that these documents are often drafted informally, not like commercial contracts? Attorney Mark.
So, when saying about contracts, so yung contract, sabi ko nga, it's only a proof. Proof yan na anong klaseng relationship sila, yung contribution mo of the money, property, industry to the relationship. So, yung tinatawag na contract should be clear. Kailangan clear yan, but of course, kung malabo yon, so we follow the rules na kung sino yung causing the ambiguity should be interpreted against sa kanya. Yun yan.
Pero kasi as we discuss contracts, no? Contracts are presumed to be consented by both parties. It's not unilateral. So, ibig sabihin, once they agree on that and that governs their relationship, then that is the rule sa kanilang dalawa. Ito yung susundin natin, 60-40 tayo, 70-30 tayo, yun yung susundin natin kasi yan yung nasa kontrata. So, klaro yun. Pero hindi ibig sabihin nun na yun lang din yung lahat ng proof nila. Kasi pwedeng yung isa magkaroon ng mas maraming proof in the later time as they go with the relationship na mas marami pala siyang na-contribute. So, hindi na yun yung maging basihan, kundi yung actual na talaga na contribution. So, ang tanong kasi doon, should we, informally execute a contract? Why informal when it could be formal, right? So, why execute it into everything, lay down na lahat ng provisions. Attorney Mike, if you agree with me, are you always agreeing with me?
But in reality, pag mahal mo yung isa't isa, hindi kailangan ng kontrata kasi ang love kasi is based on trust.
Yeah.
Yun ang problema kasi in reality, mahal mo yung isa't isa, bulag ka sa lahat. Hindi kailangan may resibo kasi pag may resibo, kung wala kang tiwala sa minamahal mo o sa yung resibo,
pero actually,
ilagay mo kontrata.
Attorney Mark,
Diba?
that is the issue sa prenuptial agreement.
Yes, tama.
Hindi sila gustong mag-execute ng prenuptial agreement. Sabi, mahal naman natin isa't isa, bakit pa tayo mag-prenup, di ba? So, yun din yun eh. Pero ang prenup, syempre, iba yun kasi bago magpakasal, yun na yung agreement.
Tama.
So, dapat, ito lang ang hindi klaro sa 148 and 147 and the Ursua case. Did they execute or they made those contracts, not the Ursua, 147 and 148? Am I talking about 148? 148. Should it be after the union or before the union? Diba?
Parang walang distinction yata.
Wala.
Kasi wala namang
It's not
prenup
yet clear.
because they're not considered
halimbawa,
married.
kami ni Attorney Mike, Kunyari lang to.
Okay.
Kasama, kunwari
Kunyari lang to, Attorney Mike. Tayong dalawa may legal impediment. Ay, meron. So, anong gagawin natin? Kailan magsimula? Kailan i-execute ang contract? Should it be before the union nating dalawa? I mean, living in together? Or should be along the way that we live together?
Parang along the way,
wala,
no?
diba? Parang wala. So, maybe that part could evolve in the later time also. Kasi dapat klaro din yun eh. Kasi nang nagsimula tayo, meron na tayong contribution eh. But later na tayo nag-agree. Right?
Baka naman mamaya, partner, dahil dito sa ruling nito, kahit yung mga dates, di ba? May resibo, kala mo linilibre ka, yung pala tinatago lahat ng resibo.
Pero date pa yun, Attorney Karen. Eh. Hindi pa sila nag-live-in together.
But in
Hindi
real
kahit
life,
sa date.
But in real life, walang resibo, walang kontrata.
That's the point nga
That's your real
eh.
life. Kasi
Yeah.
kung hiningi mo yung resibo ng girlfriend mo, ng boyfriend mo, parang baka ma-disappoint.
Or mag-away pa.
Mag-away pa kayo. So, in real life, but I don't know kasi most of my friends, mga kilala ko, pag in relationship, walang kontrata. Ang kontrata is purely meeting of minds na
And
mahal
hearts.
nila ang isa't isa, meeting of hearts. Yun lang talaga ang relationship.
Yeah. Good point. Pero kasi, dito ba sa kaso ng Jose versus Ursua, isa lang ang abogado? Kasi I know Attorney Ursua is a lawyer. Pero yung
Yes.
partner niya before,
Joseph,
yung ex niya is baka hindi abogado. Kasi bakit kinonstrue yung ambiguity against Ursua?
I think there was something na ginawa doon ng isang party na kaya yung ambiguity na construed
Baka siya yung
against.
nag-draft,
Kasi
no?
baka yun nga, baka ano to eh, unilateral lang yung or one-sided lang yung contract. So
tama. One-sided.
hindi ma-consider yun na fair din sa kabila. Kaya yung ambiguity was construed against her. But ang tinitingnan kasi natin dito, Attorney Karen, no, is yung mga LGBTQ, wala lang sa kanila yung akin na yung resibo, wala sa kanila eh. Pero pag between man and a woman, masyadong masakit yun. Bakit mo kinukuha na ng resibo? Pero sa kanila, that's normal. I have a lot of clients na ganun eh. Na magre-resibuhan talaga.
Talaga?
Oh yeah, they're already bright into thinking na in the future pwedeng maghiwalay because that always happens.
But in love kasi, bobo ang pag-ibig. Hindi ginagamit ang puso. Hindi ginamit utak.
Hindi ako makarelate yan, Attorney
Puso ang
Mark.
ginagamit.
Magkaiba approach nila, no? Kaya interesting. Kasi
Yes.
iba, ito talagang all heart si Attorney Mark. Attorney Hazel, very practical.
I'm more on criminal cases. So maybe that's the explanation.
Parang ang presumption ni Hayes, lahat ng tao kriminal.
Correct.
Lalo ng mga lalaki.
Ako, kaya pala sige, delikado pagka-date mo to. No? May baka may papapirma sa'yo. Ito, pakipirma.
Si Atty. Mark naman di ba?
Oo.
Pag-ibig.
Pag-ibig. Ganun yan.
Parang ano pala siya, meron pa siyang hangover from Valentine's. We're gonna go to another 6 minutes of discussion.
Naubos na natin yung time sa 2 minutes kanina.
So, ano lang, but before that, ito isingit ko lang very quickly kasi related din naman. Di ba dati, bago nagkaroon yata ng family code, before that, the presumption, once you get married, a man and woman, the presumption what will govern in property relationship was the conjugal partnership of gains, di ba?
Tama.
Pero it evolved. They decided, hindi, absolute community. Bakit conjugal partnership? Nagmamahalan yan eh. Ibig sabihin, yung what is his is hers, hers is his, sharing, di ba? Yun ang nangyari, di ba? Yun ang reason why. Pero alam naman natin, hindi totoo yun. Di ba? So,
Kasi in marriage kasi, love is not enough in marriage. Kasama doon ang pagtitiwala. Trust talaga. And yung tinatawag na respect with one another. Yun, lagi nandun eh. Ang tanong dyan, pag ginukuhan mo ng resibo yung girlfriend mo, yung boyfriend mo, may tiwala ba? May respect pa? So, red flag na yan for a relationship. Pag resibo, red flag na yan. Hindi mo lang alam, but in the near future, you will realize the red flag na
Alam mo, pag hininga mo yung girlfriend mo sa date ng receiver or whatever, siguradong pag uwi nyo, tulog ka mag-isa.
Tama.
That's the big turn-off, di ba?
Tsaka hindi na natin yan ugali talaga, Attorney Mike, that we ask for resibo, 'di ba? Hindi talaga ugali. Hindi yan Filipino character na magre-resibuhan tayo. So maybe those LGBTQ na na-expose lang sa foreign countries and they're so practical, yun lang sigurong nagresibuhan, which I'm referring also to my clients. Pero sa Filipino tradition and ating mga
You don't
culture,
see it
hindi
as
talaga. Definitely. So maybe this will be their guide, this Ursua case, and the Article 148 also. At saka, hindi to masyadong natatakal 147, 148 Only pag nag-aaway, di ba?
Yeah.
Pero in ordinary language, nagdi-discuss magbabarkada, magkakaibigan, they don't explain this. Pero since lumabas itong Ursua case, then nagiging na siya, trending.
And kailangan natin i-differentiate na yung relationship ng business partners iba sa relationship ng romantic partner mo. Hindi kailangan same concept kasi yung romantic partner may love kasi nakasama diyan In business kasi focus ka lang profit. That's business trust, but in relationship, mga same-sex marriage or live-in partners, may emotional na involved diyan, may trust na involved, and of course, lahat dyan, buhay mo, involved lahat dyan.
Difficult to mix. Kunyari, love and business.
Yeah,
Medyo
iba yan. Kasi in
difficult
business,
to mix. Diba?
your objective is profit.
Yeah.
In love, your objective is happiness.
Romantic si attorney.
Yun, nagda ako makarelate, attorney.
So, kung ganon,
Talaga may hangover pa sa Valentine's.
so kung ganon pala, pagka same-sex marriage, let's say you co-own a property, let's say condo unit, tapos pinangalan mo sa inyong dalawa as co-owners. Pero as soon as maghiwalay kayo, kung wala kang pinakita na pruweba na ikaw lang ang naglagay ng pera para bilhin yung condo unit na yun.
Ang presumption equal.
So you're forced to...
Pero, Attorney
Split.
Karen, the title itself says na co-owners kayo. So 50-50.
Oo. Yeah.
No need for other
Kahit
proof.
oo.
No need for other
paano
proof. That
kung
speaks the
yes.
title
So,
itself.
title
Yeah.
will govern.
Yes.
What if your partner suddenly shows na meron silang mga acknowledgement agreement din na I'm the one 100% that put in the property. Which one will
For example,
prevail?
ikaw, you have a business, yung partner mo, walang negosyo, nag-depend lang sa'yo. So, 100% ikaw nagbigay doon. So, based on same-sex relationship, so, 148, actual contribution. So,
Actual contribution even if pumayag nung in love pa kunwari yung let's say same-sex marriage, so dalawang boys. Kung kahit pumayag yung nagbayad ng 100% na malagay sa title, yung
Okay lang.
boyfriend niya,
But,
okay lang yun?
but in my opinion, no, it's not, Attorney Karen. The title speaks for itself. The title says they're co-owners, so both of them have 50% sharing.
So your legal view is the title
Yes,
will
it's
prevail.
the title.
But for you, because of
hindi.
this decision,
Yung-
is it the contribution?
yung sabi ng batas kasi, yung 50-50, yun ang presumption pag walang proof. But if there's proof na ikaw yung 100% nagbigay based on actual contribution. Kasi
But the title,
148
Attorney Mark, is already the proof itself. It's an evidence. It's a documentary evidence that could be presented in court,
there is a
right?
possibility that you have the title but the money hindi galing sa yung pagkuha ng property na yan. So it's only a proof.
It's a rebuttable presumption
rebuttable
in your
presumption yan. Kasi sabi ko nga under 148 based on actual contribution of money, property, not based on title. So nakalagay sa Ursua case, ang nakalagay sa pangalan, ibang pangalan ang title sa isang tao, but inamin niya na 50-50 sila. So it means based on actual contribution. So sinabi ng Ursua case, ang basihan ng property relationship or yung ownership is based on the actual contribution of money, property, kasi nakalagay sa 148 based on actual contribution. Pag walang resibo, walang ebidensya, the presumption is equal ang ownership nila.
So, yung punto lang sa titulo, no? Because if I recall my
Land
property
titles
line
and
titles,
deeds,
di ba? Yung titulo, sinasabi nila, you don't have to go beyond what is in the title.
Correct.
The title, that is the basis for the torrent system.
Yes.
That's why it was adopted, para hindi confusing. Kung ano yung pangalan nakalagay sa titulo, yun ang may-ari.
Yes.
Di ba? Yun ang yung basic, di ba?
But may exception.
Yes.
Yung tinatawag na mirror doctrine.
Okay.
Yung mirror doctrine, if you're a buyer, for example, if you buy a property, huwag mong i-depend lang sa titulo. kailangan kang mag-investigate sa mga kapitbahay, ano yung history ng lupa, bago mo bilhin under the mirror doctrine.
Yeah, pero
Okay.
doon sa actual contribution na pinag-uusapan, yung sinasabi ni Attorney Mike na talagang yung title nakasulat doon, co-owner silang dalawa. Are you going to disagree with that what is written on the title, 'di ba? What's written on the title, co-owner silang dalawa eh. So that is already a proof na silang dalawa ay co-owners. So although this is debatable maybe in court, no? But my stand on this, my opinion is that the title will be the basis of their
kung co-owner in the sense that, okay, there's 50-50, there's 60-40, there's 70-30. Paano na-determine for that, for example, for that title? Let's say, so and so, no?
pag
owns
co-owner
this.
kasi, Attorney Mike, equal share kayo nakasulat yan dyan.
Doon sa, no?
Yes.
mismo.
But ako
Even
kasi,
if we-
I kind
if
of
we do
agree with
the-
Attorney Mark's interpretation that given this decision of the Supreme Court, you could also argue that pwede ka magpresenta ng evidence kung magkano ang kinontribute mo, and based on what you prove, then either you own 100% of it kasi walang kinontribute yung isa, or you own 70% of it kasi 30% lang pala nabigay mo.
Kasi pwede naman yung titulo is based on trust lang.
Yeah.
Trust lang, so ang beneficial owner, iba talagang beneficial owner.
Kasi ang case ni Ursua is different eh. Hindi naman nakalagay doon na silang dalawa co-owners and then that is the one rebutted in court. Tapos sinabi na, kung yung makapag-submit ng proof kung sinong may actual contribution, yun yung may-ari, di ba? Or sino yung mas mataas na ownership. Hindi eh. We're not basing on a title here that is based on co-ownership. Iba kasi ang pinresenta nila sa court. So it may change. It may also change. Well, it depends on if there's a case similar to this, and maybe there are many situations like this na co-owner sila sa title pero sa totoong buhay hindi naman talaga sila parehas ng sharing, right? Pero in my own opinion, para dito sa titulo, yun lang talaga ang basis eh. Kung ano nakasulat doon, co-owner sila in equal share, yun. So, different siya doon sa evidence na pinresent sa Ursua case.
Talagang when you have as many lawyers, that's also as many views that you will get.
Just like cameras.
Thank you, attorneys. We'll take a short break. When we return, closing reflections on the court question. Should co-ownership remain proof-based to protect property rights and prevent abuse? This is Abogado.
Welcome back and thanks for joining us. You're still watching Abogado. Tonight, we ask a question that many couples avoid until a crisis forces them to face it. Because when people live together, love is real, contribution is real, sacrifice is real. But in court, what matters is often what can be proven.
And the law must balance two competing values: protecting the partner who contributed but has no title, and protecting property rights from false or exaggerated claims. We now ask our guests for these closing reflections. Attorney Mark, your final statement.
My final statement, for example, common same-sex relationship, it should be based on actual contribution of money, property, or industry. So yun yan, hindi kailangan yung papel o ano ba dyan, but based on actual contribution. Kasi there's a possibility na iba yung nakapangalan, but iba yung nagbabayad. Kasi sabi ko nga, in a relationship, mostly love is blind, mostly based on love, based on trust, based on yung tinatawag na purely love talaga ang base dyan. Pag love kasi, wala na yung mga pagdududa. Pag love kasi, todo ka ng bigay, so wala na yung mga resibo, wala na yung mga papel. So it's actually based on actual contribution, lalo na pag same-sex relationship. Ganun yan.
Pero since nag-evolve na rin kasi ang ating mundo, no? So mag-i-evolve na rin dapat ang karakter ng mga tao. Dapat meron na talagang resibo. Kasi kung wala yon, anong ipapakita mo sa korte? Sasabihin mo, ako talaga ang nagluluto, ako ang nagsiserve, ako ang nag-aalaga sa kanya. You cannot say that. You always have proof. There should always be evidence. So ako, I stand with evidence.
Kung mahal mo ang tao, may tiwala ka sa tao na yan.
Pero hindi lahat ng panahon may pag-ibig na nananaig. Tama, Attorney Mike?
Kung wala kang pag-ibig, bakit ka nakipagrelasyon?
Kasi hindi aabot sa korte, hindi aabot sa korte kung merong pag-ibig na tumatagal. Tama? Kaya nga sila nag-aaway.
One quick question before you go. Very quick answer.
Personal. Tumatawa na sa studio, no?
Not personal, Attorney Mike.
Of course na. Wala namang personal. Pero one quick question before we end the program. No? Quick answer lang. Sa inyong pananaw, kailangan ba amendahan ng Kongreso yung family code
Good
para
question, partner.
ma-modernize, to recognize, no, and to modernize the existing laws?
Kailangan ang batas natin hindi bulag. Kailangan alam nila na may nag-live-in dyan na walang kasal, may iba dyan, babae-babae, lalaki-lalaki. Ano yung protection sa kanila? Kailangan ang batas hindi pwedeng closed-minded, open, lalo na ngayon na ang dami na nakasama dyan na hindi kasal, lalo na yung mga same-sex relationship.
Okay.
Pero kasama naman kasi kasama naman doon sa pag-recognize ng kanilang relationship, kung live-in man, wala ang problema nun. Wag lang, in my stand, wag lang yung marriage. Okay, I still stand as, the classic. I'm sorry. Pero sana hindi magalit ang LGBTQ family sa akin. Pero kung mag-live-in, walang problema yan. Pero wag lang yung marriage. Because for me, it's very sacramental. So, dapat siguro, hindi naman din sila pinabayaan ng batas eh. Meron naman tong Ursua case that is recently decided.
Yeah.
And then, it has already a protection to them. So, okay na yon. Okay na yon. So the evolution may be pwedeng amyandahan to the extent kailan ba magsimula ang agreement nila? Doon ba sa pagsimula ng live-in partnership nila or doon sa kalagitnaan? Paano yung nauna nilang mga pinag-contribute, di ba? So dapat medyo yung part na yon, the reckoning period, where should it be? At
Baka
the
ang Supreme Court mag-issue ng clarifying guidelines.
Pwede.
No? After
Pwede.
this
Pwede.
rule.
Pwede.
Yeah.
Nakakatuwa naman. Pag magkaiba yung views at magkaiba ang personality. Thank you so much, Attorney
thank
Mark
you.
Kristopher Tolentino and Attorney Hazel Hayes-Mecking for
Yeah,
a
can I
timely
have
and
my
meaningful
last
discussion.
just a plug for my Abogado ng Bayan on social media platforms and also at our Making Law Firm.
Okay, thank you very much, Attorney Hayes. And, live-in relationships are not rare. We all know that. That's a reality in life. They are part of the Filipino life. And the law is slowly catching up to the realities of love, sacrifice, and shared building.
But until the law changes, remember this. In court, love is not enough. You need proof. And if you are building a life with someone, protect yourself, protect your partner, and protect what you both work for. So, Attorney Mike, sabi mo nga, resibo. This is Abogado. Good night.